Next tonight, who qualifies as a supervisor in the workplace? That might seem obvious most of the time, but as a legal matter, courts have come to different conclusions. Some saying it's confined to someone with powers such as hiring and firing, others deciding on a broader definition. The Supreme Court looked at the issue today in a case where a woman claims a co-worker harassed her because of her race. Marcia Coyle of the National Law Journal was in the courtroom to hear the arguments and is here with us tonight. Welcome back, Marcia.
Thank you, Jeff.
So first, the facts of the case. Vance v. Ball State University.
Right. Well, Jeff, first of all, this case involves Title VII of the Civil Rights Act, which, as you know, is our nation's major job anti-discrimination law. And under that law, an employer can be held liable if a supervisor harasses an employee. And that's because the supervisor is imbued with the employer's authority.
The key word being supervisor. Right?
Exactly.
Yeah.
But an employer also can be held liable if a non-supervisor employee harasses another employee. But it's tougher to prove. You have to show the employer knew or should have known about the harassment and failed to act. Maida Vance brought this lawsuit against Ball State University. She's an African-American woman working in the dining services division of the university, claims she was harassed by a white co-worker, was slapped on the head, blocked at the elevator. Racial epithets were used, such as Sambo and buckwheat, in her presence. She complained, and finally she brought her lawsuit against the university. She lost below in the lower courts. The lower court, federal appellate court, said that this co-worker was not a supervisor and took the definition that is probably the most restrictive, that is, a supervisor has to be somebody who can make a tangible employment decision, such as hiring and firing.
All right, so today it made its way to the Supreme Court, and her argument, her lawyers are arguing for something broader than that.
Absolutely. In fact, it was an interesting argument because not only her lawyer, but the lawyer for the federal government and the lawyer for the university did not support the lower federal court's definition of supervisor.
Even though they had won down there.
Yes, even though. But there were nuances here. First of all, Ms. Vance's lawyer believes that the correct approach or standard is to say that anyone who controls your daily activities is a supervisor for liability purposes. And the federal government argued, Deputy Solicitor General Cerise Srinivasan argued that the court should accept the EEOC, the Equal Employment Opportunity Commission's approach, which is either or. You either do make tangible employment decisions or you control an employee's daily activities. The university argued basically will accept the broader definition, but there have to be some meaningful limits on it. The harassing employee cannot be somebody who occasionally controls your activities. It has to be a meaningful control.
So on the side of, in this case, it's the university as the employer.
Yes.
The implications for wider implications for other companies, they would be arguing against the broader
absolutely.
Definition,
the
right?
U.S. Chamber of Commerce and a number of
It's a big deal
business.
for them. Huh?
It is. It's all about money liability.
Yeah.
If the court accepts the stricter definition, the lawyers and organizations that represent workers fear that employers will start moving categories of workers into the supervisor category in order to avoid liability, whereas employers are concerned with a broader definition that they will have greater potential liability.
And did the justices tip their hands, or any interesting questions?
Well, I didn't see a lot of support for the strict definition, although Chief Justice Roberts pointed out that there is an advantage to that, and that is, clearly, it's a bright line rule what the analysis is going to be. He worried that a broader definition creates sort of a continuum of employees who fall on that continuum as to, individual facts of each case are going to matter, and courts are going to be drawn into endless debates as to who is a supervisor.
All right, we will await that decision. In the meantime, the court also took another action today, not arguments, but they sent back to the lower courts a case that concerns the Affordable Care Act, of course, the big event from last session.
Yes.
Right?
Well, Liberty University was one of 4 cases last term that challenged the Affordable Care Act. Today, the court sent Liberty University's case back to the Fourth Circuit Court of Appeals, because Liberty University had raised other claims that the Supreme Court did not decide last term. Liberty University wants to challenge the individual mandate to purchase insurance and the law's employer mandate to provide insurance on religious grounds. Liberty University, as you know, was founded by the Reverend Jerry Falwell, and it claims that the Affordable Care Act, those two mandates in particular, violate the free expression of religion.
So the court is saying that was not something we took up last time. Send it back to the lower courts, let them hear
rule.
it.
Right. The lower court was the only federal appellate court that refused to let Liberty University's lawsuit go forward at all because of that old Anti-Injunction Act. That was the only court that found that that law blocked challenges to the Affordable Care Act. And the Supreme Court, in its final health care ruling, said that that act did not apply.
But briefly, so now there's a chance it'll come back to the Supreme Court eventually.
I'll bet you dollars to donuts
you
that
will?
If Liberty University loses, that Liberty University will be back at the Supreme Court probably next year.
All right. I'm not taking a bet against you,
Okay.
but we'll talk about it if it happens, of course. Marcia Coyle, thanks again.
My pleasure, Jeff.